Good morning, viewers. Welcome to Konasima Shorthand classes. Get ready for dictation. 5 seconds. Start. This petition is filed under Section 482 of CRPC, praying this court to set aside the order dated 3/7/2018 passed by the 11th Additional Chief Metropolitan Magistrate, Bangalore, in CC number 3012 bar 2020, taking cognizance, registering case, and ordering process to the petitioners for the offences payable under sections 427, 428, 143, 147, read with section 34B of IPC, and to quash the entire proceedings. 2. The factual matrix of the case is that respondent number 2 filed a complaint against the petitioners, making the allegation that on 3/1/2017 these accused persons trespassed the house, caused damage to the house, threatened her, and thrown out the vessels outside the house, and hence she gave the complaint on the very same day. The police, after receiving the complaint, acknowledged the complaint, and again complaint was given on 22nd February 2017, and the police have registered the case for the above offences and thereafter investigated the matter and filed the charge sheet against the petitioners herein. The learned magistrate, after receiving the complaint, took the cognizance wide order dated 3rd July 2020, and hence the petitioners are before this court. 3. The main contention of the petitioners before this court is that the maximum punishment for the offences which have been invoked against the petitioners herein is 2 years, and hence the learned magistrate ought not to have taken the cognizance after 3 years, and hence committed an error in taking the cognizance. The learned counsel for the petitioners brought to the notice of this court the relevant offences and also section 468 of CRPC. The learned counsel would contend that the incident was taken on 3rd January 2017 and case was registered on 22nd February 2017, and final report was filed on 30th June 2020, and cognizance was taken after lapse of 3 years. Hence, it requires interference of this court. 4. The second contention of the learned counsel for the petitioners is that even on merits also, no case has been made out against the petitioners to subject them for trial. The learned counsel would contend that the building was in dilapidated condition and any moment it would have fallen due to rain and caused danger to respondent number 2. Hence, the same was narrated to respondent number 2, and respondent number 2 agreed to vacate the house in the first week of January 2017, and accordingly she removed all the materials from the house and voluntarily herself and her son removed the household articles, and after vacating the house, the same was demolished. 5. The learned counsel would contend that when the complaint was given on 3rd January 2017, petitioner number 1 was secured to the police station and he gave the reply on 4th January 2017, and the police have registered NCR and again registered the case against the petitioners herein on subsequent complaint, and hence there cannot be any criminal prosecution against the petitioners herein. 6. The learned counsel for the petitioners, in support of his arguments, relied upon the judgment of the apex court in the case of State of Punjab versus Swarna Singh, reported in AIR 1991 SC 154, wherein the apex court comes to the conclusion that if the offense is punishable for 2 years, the trial court ought not to have taken the cognizance after 3 years. The apex court discussed sections 468(2) and 469 of CRPC and comes to the conclusion that the object which the statute seeks to subserve is clearly in consonance with the concept of fairness of trial as enshrined in Article 21 of the Constitution of India, and hence the same is barred by limitation. 7. The learned counsel also relied upon the judgment of this court in the case of Sri Devadas versus State of Karnataka, reported in 1987 1 Crimes 518, wherein this court, relying upon the judgment in the case of Swarna Singh Chopra, came to the conclusion that taking of cognizance is barred by limitation and no application for condonation of delay is filed by the prosecution. Any prosecution, whether by the state or the private complainant, must abide by the letter of law as provided under section 468 of CRPC, or take the risk of the prosecution failing on the ground of limitation. 8. The learned counsel also relied upon the judgment of this court in the case of State of Karnataka versus Vasant, reported in 1988 CRILJ 3075, wherein this court held that condonation of delay, exercise of judicial discretion, delay not to be condoned as a matter of course, and sufficient cause is essential. No application for condonation of delay held delay could not be condoned. 9. Per contra, the learned counsel for respondent number 2 would contend that the offense is a continuous offense and brought to the notice of this court sections 470 and 472 of CRPC and contend that no limitation applies as contended by the learned counsel for the petitioners. The learned counsel would vehemently contend that the case was registered at the first instance against the accused numbers 1 and 2 and other two accused who have been arranged as accused numbers 3 and 4, and those accused have absconded. That's all.